I think what happened is Abood was decided in 1977 that over the years we kept filing one case after another, teachers, other public sector employees saying we shouldn't be forced to pay dues, the Abood system doesn't work, and eventually the Supreme Court saw it. Just keep knocking at the door, showing the infirmity of this compulsory fee system that had enmeshed Mark. And so the Supreme Court took its first case in 2012, a case called Knox, and sort of said, yeah, we don't know if this Abood case makes sense. 2014, another case called Harris versus Quinn, the court very emphatically said, we really don't think Abood makes sense. One day we hope we have a case where we can overturn it. And then along comes Mark on his white horse that gave the Supreme Court the vehicle that it needed to actually overturn Abood and to hold it unconstitutional under the First Amendment for the government to force anyone who works for the government, public school teachers, state workers, local government workers, to pay compulsory fees to a union. And one of the key decisions or sort of aspects of that was the court's realization that everything a government union does is political. You know, the function of an exclusive representative is to petition the government, lobby the government over what its policies should be. So, for example, a teachers union in the public sector, its function is to lobby a school district over what its educational policies should be. That is a political activity. That is political speech. And so to force an individual to fund that political speech violates the First Amendment. The Supreme Court should have realized that way back in 1977 in Abood. They didn't. It took them about 40 years to realize their mistake, but ultimately, because of Mark's case, they did, and they corrected that mistake. And so it was very great to be part of the process, to be able to represent Mark before the court in that case.